Good afternoon, and thank you for joining us today. I'm Nita Beecher, and I'd like to welcome you to the Fortney Scott webinar entitled DOL in Trump 2.0. This webinar is recorded. I'm happy to be presenting today with David Fortney and Adriana Joens, and I'd like to turn the program over to David Fortney. If you'd kick it off, sir.
Love to. Hey, Nita, and welcome everyone. Here we are transmitting from downtown Washington. I don't think we're in a war zone. It kind of looks like a war zone, but there's quite a bit of extra police, as we've all heard about, but we'll leave that for a different webinar. What we really want to do, though, is focus on the changes, particularly with the U.S. Department of Labor in Trump 2.0. First, just a brief word about us. I think most of you joining us today do know about our firm, but we are Washington, D.C. based. We do deal with the federal agencies, including the Department of Labor, which is, if you will, on the menu for today, but also with the EEOC, the NLRB, and a wide range of other agencies that have become very involved in implementing the Trump administration agenda. All of our lawyers have really deep experience and expertise on these matters. We deal with a full range of workplace matters, both domestic and a number of our clients are multinational. And we have the privilege of also working with them on issues that span the globe, along with many other partners. So anyhow, the other final thing, just if you don't know about us, please check out the podcast, DC Insider Employer Update. We have lots of fun on that. We give lots of great updates. In fact, we're doing a podcast focusing on the DOL, and we have a really exciting podcast we're going to drop in the next week or so dealing with the Labor Department's AI guy who you'll meet and get to know. And it's actually very, very exciting what's going on there. So Nita, let's just jump right into what the program is today and get going.
Absolutely. So we decided to do a very comprehensive, sort of high-level look at what's going on in the Labor Department, because unlike a lot of the other agencies, they've really started to roll out right away. We're going to talk about who are the players, so you'll know who the players are, whether they have numbers or names on their back or not. One of the things when we talk about cutbacks in the federal government, you expect is there going to be new programs around voluntary compliance. We're going to talk about that. Obviously, along with every other agency, there's a big deregulation push. As David mentioned, they rolled out the American AI Action Plan, which focuses on very much on the Department of Labor and ties into the apprenticeship programs as well. You may remember that the Biden administration had a whole bunch of regulations. We're going to talk about where they stand, although they're probably all about to be on the dust heap of history. Finally, there are a few last things we want to close up with, and then final thoughts from the three of us. And so, David, you want to kick it off for us?
I'd be happy to, Nita. Thank you. So, Labor Department takes shape, and that I think is really interesting. And we'll kind of let me suggest one thing that I think you'll see as we talk about some of these developments. Even though a number of agency heads aren't yet confirmed, and they were nominated reasonably promptly, but the Senate confirmation process, as we've seen in the news, is kind of at a glacial pace. That's politics 101. But that typically slows down the work of the agencies that the nominee will be heading up. That is not the case here. With the Trump 2.0 Labor Department, they are just tearing up the track. There's a lot of things that they're moving forward on. And the usual, I'll call it caution, that we've seen is something that we've seen thrown to the wind a little bit. And they're really put the shoulder to the wheel and they're implementing. Let me give you a few of the guiding principles that appear to us. I mean, we're what, 6 months in now on Trump 2.0. So let's talk about some of those principles. And they're spelled out in the next slide. If we can just take a look at that. Kind of these appear to be the points that folks are really kind of organizing the programs around. Individual merit, give everyone a fair shake. Everyone gets selected on his or her individual merit. This is the underlying justification for eliminating what is, we should have put air quotes around that, illegal DEI. That is a term of the administration's. It is not a legal term. It's not our term. but that is the primary justification. Additionally, the individual freedom, that is, that individuals' freedom should be zealously protected. And that particularly leans into the religious freedom space. And we're going to, again, unpack some of those changes that illustrate that. Deregulation. Not a huge surprise that Democratic administrations traditionally impose more regulations, Republicans less. What is significant is the breadth and depth of deregulation that we're seeing. And that's both DOGE, which has received a fair amount of attention, but also this laser focus on deconstructing what's called the administrative state. And we're going to talk about how that gets unpacked at DOL. We did a whole separate program on the America's AI Action Plan released by the White House about 2 weeks ago. And as I said, we've got a podcast coming up on that. But this really is a key point, and it influences a number of the programs and approaches. That is the use and reliance on AI as a significant tool. Two other points to hit on quickly. First, reimagining education. So the traditional K through high school and then post high school education, typically 2 years or more often 4 years of college, that has been, I'll call it the default, even though less than 50% of Americans may actually have followed that pattern. That still is the perception. This administration has really said, no, we're going to completely aggressively reimagine workforce education, the education, what constitutes success in the workforce. So it's more than just we're going to train people to do apprentice, so-called blue collar or skilled jobs. It's much broader and deeper than that. And finally, the immigration challenges, those will have lasting impacts on the workplace. The Labor Department has part of that portfolio. The temporary workers, various visas that are issued for agriculture and other work opportunities, what the impact there will be, as well as if there's restrictions on immigration in the workforce, how that deficiency in workers is filled. And some of this goes to changing educational, reskilling, upskilling opportunities. So all of these pieces kind of fit together, but these are ones that we think help, because sometimes you look at each change like, what's going on? Why is this? We view this as kind of the master, I'll call it the skeleton that helps, kind of the glue that puts things together a little bit.
Well, David, I think it's fascinating because you know some of these players and you've been talking with them about how they're rolling these things out.
Sure. And so let's just say a word about, of course, we have the leadership confirmed. Secretary Chavez de Remer, I think her key bio points are pretty well known at this point. The Teamsters strongly promoted her candidacy, if you will. The president did appoint her. She was confirmed. Her role over those 6 months has been primarily outward facing. She's done a multi-state tour, multi-weeks, kind of, interface, attending the cabinet meetings, covering that. But who's kind of running the day-to-day operations and very integral, I think, is Deputy Secretary Sonderling. Keith Sonderling, who many know, is very substantive, very knowledgeable, very great depth. Both he formerly was at the Labor Department in the wage hour area, and then, of course, at the EEOC, served a term as commissioner, where he focused on AI, and I think really developed a well-earned international reputation for expertise in that area. One thing I'd say is that about Deputy Secretary Sonderling, I think that he has been very helpful in ensuring and helping support the White House process for selection, getting vacancies filled, worrying about agencies and slots like the Mine Safety Review Commission or the OSHA Safety Health Review, OSHRIC or MSHRIC as they're called, and some of these other agencies that aren't the top of anyone's list, but day to day, you need to have those agencies staffed for the gears to turn. And I think that Keith, Deputy Secretary Sonderling, it deserves great, credit for making sure that the administration appreciates and stays focused on that. as well as I think really putting the shoulder to the wheel in getting the Labor Department staffed up quickly. So when we talk about the Labor Department moving quickly, I think that if I had to pick one person to point to and say, how does that happen? More so than in almost any other cabinet agency, I would say it's Deputy Secretary Sonderling.
Well, David, if you look at the next list, this is despite the fact that there are 10 nominees for major positions within the Department of Labor. They are waiting for confirmation. They are all sitting at basically at the Senate, and that includes, for example, David Keeling, who was from UPS, will be at OSHA. The former EEOC chair, who actually right this minute is at the Employee Benefit Security Administration, but she will be confirmed as the head of the Pension Benefit Guarantee Corporation. Solicitor of Labor, Jonathan Berry, who was the author of Chapter 18, for those who are as much wiggy as we are, that is Chapter 18 of Project 2025. And Andrew Rogers, who currently is the acting general counsel at EEOC, formerly was the chief of staff for acting chair Lucas, and he will be at Wage and Hour. With Senate not coming back until the 2nd of September, and with only 28 days until they run out of, they have to shut down government, it'll be interesting to see if these guys get actually confirmed in that time.
I've lost the count. I mean, they're caught in a big log jam, 140, 150 nominees in
Correct.
that range, judges, various officials. I mean, below the cabinet, there are all these other nominees. And Andy Rogers, he is a kind of return. He was in Wage Hour in Trump 1.0. So I'm very excited about him because I think that he's going to bring some, again, some real, these folks don't have any learning curve. These folks are going to hit the ground running. They are prepared and have been getting themselves prepared in order to take this on.
Well, Adriana, we hadn't heard from you yet. What about the Labor Department's budget for 2026?
Sure. So there's an interesting development. With regard to the budget, the DOL had proposed a 35% reduction, and that went from 13.3 to 8.6. So reflecting a deregulatory posture, it was also giving us the information, as most of you know, it would be eliminating OFCCP, Women's Bureau, Job Corps. But as this DOL has been taking shape, as this administration has been, building out certain programs, which we will discuss in this presentation, Senate Appropriations Committee, whether they recognized it or realized that they went ahead and instead approved a 3% increase of the budget, DOL budget instead, and also surprisingly kept OFCCP, reduced it just by a little bit to 105 million from 111. So there's this very wide discrepancy, but we believe this indicates how big of a role DOL is going to have. And with these programs, again, that we'll talk about later on here. But something to note as well, if Congress defaults to a continuing resolution, then agencies are going to remain funded at the 2025 level. So this will preserve the current operations, obviously freezing hiring though. And go ahead.
No, I was just going to say, I'm sorry. I find it fascinating that the Senate Appropriations Committee, on a bipartisan basis, took the White House budget, basically tore it up and said, forget it. No, no, no. We have a completely different vision of the funding level and the activities. I mean, I am hard pressed as I look around the Washington environment today to think of other examples, bipartisan, of overriding the White House. That does not happen very often. And I think this is very, very significant. I now, this is but one committee. It's the Senate. It's not the House, and but it's the Appropriations Committee. But it's just an interesting play. And this is going to be, as you say, sorted out in the next 30 to 45 days. I'm definitely keeping an eye on this.
Not 30 to 45. Well, maybe, but it's maybe 30 days. They're going to run out of time.
Yeah. Well, this gets to because they're supposed to figure out the entire budget for FY 2026 and get all the nominees cleared too. Yeah, that's not happening.
Right.
That's not happening.
Right.
Well,
Um,
let's go to the next slide because what we want to talk about is so the secretary had testified in front of Congress and she was defending the budget that they had submitted, which is gutting them basically. And she said, well, we're going to have to do we're going to do more with less. And basically, if they're going to do that, they have to have different ways of doing it. So, what I think we're seeing is going back to voluntary compliance, ways of pushing the enforcement back on employers. And so, Adriana, how are they doing that for this upcoming year?
Right. So the DOL recently launched, well, I would say relaunched new opinion letters because there were several agencies like the Wage and Hour Division already had opinion letters, but in addition to that, they also expanded the opportunities. And with this relaunch of opinion letters, it signals a deliberate pivot toward transparency and predictability in dealing with enforcement. And with these opinion letters, also opportunity for employers to be provided with protections in that these opinion letters in the past have had courts have deferred to these opinion letters. They've been held to that standard to be the what the employer provided or enforced or implemented within their workforce. And so therefore that's what was shown as good faith or goodwill and then would provide those protections. So we're seeing that internally the agencies could also be using these opinion letters to triage enforcement or prioritize guidance as well. So we can see that they might be taking what is being asked for these opinion letters and then using that to figure out going forward what other guidance do they need to be providing to the employers for compliance purposes. But the opinion letters are helpful too in that there's this collaboration now that we're seeing with the Department of Labor uh, and we're seeing also that the DOL is encouraging these opinion letters. We're actually involved in several of these, and the Department of Labor is uh, it wants to be able to provide that type of I guess interpretation or guidance to employers. So this signals a different type of I guess, like I said, the transparency enforcement than the previous administration.
Well,
With
and
Go ahead.
with that, I mean, that's one step. What's the next step, David?
Well, in addition to seeking opinion letters, which we've been very successful in engaging on that, they also have stood up a number of self-audit programs. These are basically where, based on prescribed metrics that the Labor Department gives you, employers subject themselves to a set of analytics, and basically they provide those results to the Labor Department. It may include some remedial steps, some corrective actions that are being taken, and you get the Labor Department then to review it and effectively, if you will, bless it, saying, yes, your review was good, your results were good, your remedial actions were all good. Notice that these programs, Wage Hour, VETS, OSHA, the benefits program, and mine safety, the Labor Department is the enforcer, if you will. These typically do not have private causes of action attached to them. Wage Hour has a few. Adriana, you can talk about that in a moment. But these others, the Labor Department is the one that would be bringing enforcement action. So you have an opportunity to go to the enforcer voluntarily and say, look, I checked, and in some cases, I didn't have this right. I had a little bit of gap in my compliance, but I fixed it. Here's what I did. That is and the Labor Department says, great, good. That's what we want. We want to promote compliance. We want to promote voluntary remedial action if it's appropriate or required, and we want to promote going forward. The OSHA VPP program has demonstrated to save lives and significantly reduce injuries. It's a highly successful program. And in that, one of the cornerstones is you actually go slightly more than the basic regulations require. It's not mandatory, but if you want to be in that program, then you're not subjected to OSHA audits as frequently, and you get some relief on that end. So it's win-win. If an agency doesn't have as many resources, it can target on those that aren't in these programs. It's a big win for the employers and those workers who know they're in compliance, and if there was a gap in compliance, that it's been remediated with back pay or whatever needs to be done for remediation. So it's a great program. But Adriana, can you talk about that first one, the wage hour, the what we call the paid program? Because that one really has some big legs to it.
Sure, yeah. As David indicated and kind of provided this great summary with regard to the pay program, this is in conjunction with working with the Department of Labor's Wage and Hour Division. And and the significance of this is that this provides, if you will, a safe harbor once you follow these steps. But there are a couple caveats here that you have to be aware of. And something I wanted to provide an example. I mean, this is a paid program. Trump 1.0 had I guess activated it, if you will, because it's not the first time a paid program has been used in the system, but or by the DOL, but they reactivate it, and this is allows for employers to take those steps, as David discussed, where they conduct these self audits, they identify these potential problems. So the paid program, it allows the employers can work with the wage and hour division to correct and pay back wages. And the importance about this is the fact that under FLSA, you cannot have back wages protected from future claims without having a judicially approved settlement or under supervision of the Department of Labor. And so this allows an employer to voluntarily work with or collaborate with the Department of Labor, come forward with these potential violations, take the necessary steps to protect itself. Now, again, the caveat that we want to point out is the fact that, before you go jumping into this, as we've done in the past, you need to vet the audit findings before you bring in the Department of Labor here. And that's because you need to assess the state law overlap and consider whether there's perhaps alternatives. But there are many state wage laws, California, New York, Illinois, Massachusetts, that they provide broader remedies under the FLSA specifically, including longer statute limitations or treble damages and attorney's fees and so forth. So that's something that you definitely need to be aware of prior to engaging the Department of Labor with this program.
Let me
Well,
just quick.
that's
Sorry, Nita. I just want to share a real quick example to illustrate what Adriana's just unpacked for us. You get someone who is kind of on the margin, whether they are properly classified as a white collar exempt employee or whether they should be an hourly employee. Think of various low level technical employees that often walk that line. There's a lot of different occupations. If you determine that perhaps you have had them misclassified as exempt, this allows you to reclassify them, to look at what the hours were worked and make a reasonable approximation on what the overtime premium that should have been paid that was not paid, to reclassify, make the payment, and avoid private class or collective litigation, avoid paying plaintiff's attorney's fees, avoid paying liquidated damages. This is huge. If you're in the right opportunities, this can be extremely beneficial to employers. So the paid program, I think, is a big, big darn deal.
I agree. So we're talking about these are the voluntary programs that they've rolled out, but we also have the deregulation push, which I think we need to sort of talk about. You all have heard about. So let's go to the next slide. We know that President Trump, first of all, it was one of many executive orders he issued. He wants to deregulate all the agencies, beginning with an executive order on January 31st, unleashing prosperity through deregulation. He also had another one, ensuring lawful compliance and implementing the DOGE regulatory initiative, which we'll talk about in just a minute. And then in April, he issued a presidential memorandum directing the repeal of unlawful regs. So first of all, DOL's taken this to heart. They very quietly have already deregulated. They've gotten rid of 69 DOL regulations. Obviously, those of us in OFCCP land, 11246 is about, we're losing those regs. They eliminated affirmative action and non-discriminatory requirements for registered apprenticeships. They are removing proposals to increase minimum wage for disabled workers, also removing the proposal to extend collective bargaining to certain temporary workers. And they had proposed to eliminate a number of the employees' benefits interpretations, but the chamber and other employer groups pushed back on that. And so they are going to not remove all of those. But that's what's going on. But meanwhile, back at Doge, Doge is not gone. Doge is in the process, next slide, of, as you can see here, there's Mr. Doge. They're in the process of using AI, our favorite, to eliminate 50% of all federal regulations by January 20th, 2026. They're going to be using it's called the Doge AI Deregulation Decision Tool, which is supposed to analyze 200,000 regulations and eliminate 100,000 regulations in, what are we talking, 5 months? It's less than 6 months. There have been a lot of concerns about the legality of using AI in this way, and two, it's unclear whether the courts will allow the Trump administration to ignore these rules, which is one of the things that's going on as well. And David, we would like for you to tell us all about the presidential memo repealing unlawful regulations.
Sure. So this is interesting. This is the frontal assault. And then this occurs early on. The president issues a broad-based memo that in plain speak basically says, look, the Supreme Court has announced a number of decisions. We've talked about every one of these decisions in prior both webinars and podcasts and client alerts. But Loper Bright dealing with the adjudication through ALJ proceedings, SFFA dealing with DEI, but there's major question. There's whether improper delegation to agencies. There's a whole litany of Supreme Court law over the last 3 to 4 years that have basically said the administrative state is largely, potentially unauthorized, operating illicitly. So the president has said, all right, and really this is powered up primarily by his OMB director, Mr. Russ Vought. But the executive order directs that his agencies are to, as noted here, immediately take steps to simply repeal the regulations that exceed the agency's authority or are otherwise unlawful. So let's unpack what that means for a minute. The administration is leaning in the Administrative Procedure Act, which controls all the notice and comment, and in plain speak, you put notice and comment to put a new reg in, and you go through notice and comment to remove a reg or modify a reg. That takes months, sometimes over a year, sometimes multiple years. OSHA rulemaking's gone on for multiple years in the past, for example. It takes a long time. The administration has said, no, we're not waiting for that. We're going to cut right to the chase. Anita, I'm going to ask you to explain that picture in just one second. But we're going to cut right to the chase, and we're going to determine if we, the administration, believe that the regulation isn't actually authorized by the statute or exceeds the authority of the agency or didn't comport with the restrictions in the statute. We don't have to go through all that notice and comment. We have good cause. We'll just pull it out of the rule book right away and do it immediately. And that is, in fact, what they're starting to do. OSHA, for example, has teed up, I think, 25 regulatory changed actions, including some that were on the books already, as well as many that were pending. But Nita, I love the picture. Tell us about it.
Well, when we were talking about this earlier, this made me think of the scene in Indiana Jones and the Raiders of the Lost Ark, where this very large man with a very large sword stands up in front and he's going to come after Indy with the sword. And Indy says, "What the heck?" Pulls out his gun and shoots the guy. And this actually, on that particular day, the Harrison Ford had 104 fever. And so they were going to have a sword fight, but he was too sick. So they came up with this, but that's exactly how I feel that the Trump administration is going after deregulation. We're just going to pull out the gun and we're going to shoot those
Let's
regulations.
just cut to the chase. Exactly. That's great.
Yes.
Well, let's talk about some of the other specific regs that we know a number of our clients have focused on, Nita.
Well, and here we are, our friends at OFCCP. So, as Adriana already mentioned, DOL said, well, it's going to be gone on October 1, maybe, maybe not.
Maybe. Yep.
They've already decided that the 7% utilization goal in self ID violates the ADA under Loper Bright, so they've got to go. And as a result, they're revising the annual assessment that we have been doing because there's not going to be any data. You're just going to, I guess, eyeball it. Interestingly enough, the VEVRA hiring benchmark remains. It was interesting. So they're making very major changes in those regulations, and we'll see how that all comes out. And the original reason for changing them is they're eliminating 11246 and all of the cross references that are in the other regulations. What about damages, Adriana?
Yeah. So in addition to the wage and hour, they reduced the damages. It's good news for employers, right? So the previously in any audits, DOL would have their investigators, they would have liquidated damages, which doubled in investigation audits, and now they are no longer seeking. So this marks definitely a notable departure from like the prior enforcement trends in the previous administration. So also might, I guess, signal a recalibration toward the voluntary compliance. So again, this might be incentivizing those to come forward and to collaborate again with the Department of Labor. And also along the lines of this is OSHA, who's going to provide 20%. This is incentive for employers. So if you didn't have a history of violations and no inspection in the past 5 years, you'd also have this 20% penalty reduction. And then finally, with the small employers, they can get penalties reduced by 70%. So this is an acknowledgement of the small employers that we're seeing, again, incentivizing compliance in a different way than we've seen in the past, for
You know,
sure.
David, talking about OSHA, I think you said that they're doing some major changes in their regulations as well, including the interpretation of the general duties clause.
Right. They're cutting back on the general duties clause, which that's been kind of the go-to whenever situations come up. Heat exposure, COVID, a whole variety of things that they've tried. And that's always been a bit of a flashpoint in the history that OSHA has often leaned into the general duty clause as a gap filler. The administration, and this is again, if it isn't clearly spelled out in the statute, we're not going to play sort of a gotcha approach. And the administration is saying, no, we're going to read general duty much more narrowly, and we're not going to try to peanut butter it over anything that happens. So that's, again, a governing philosophy. It's favorable to employers. We'll see how it does in promoting employment. I just would say this OSHA penalty point that Adriana explained to us, if you've had a clean record for 5 years and you have a problem, a violation, I think this does represent, look, mistakes happen. You have to be held accountable. That's not an excuse, but it does recognize that you've also had an unblemished record for X number of years and so forth. So I think that sort of relationship is being now imparted into the regulatory state, and it does. They like to say it makes common sense, and I would have to say that does kind of make common sense to me. So that is
Right.
one of their watchwords, isn't it?
Right. Yep.
And we can't forget about AI, David.
Yeah. So we touched on this briefly, and we're just going to hit this very quickly here. But a couple of weeks ago, the White House issued the American AI Action Plan, as it's called, Artificial Intelligence Action Plan, and it really focused on how America is going to use AI going forward, including with a huge amount of focus on the workforce and how it will be introduced and used in the workforce. Let me just say quickly on the next slide, the DOL role is quite expansive under this. And Andrea, I'm going to ask you to unpack some of this and the different points. But in essence, the Biden administration had taken a very prescriptive approach. It said that AI is potentially very risky, very dangerous, particularly when it comes to workplace matters, kind of the European or California approach for our multinationals or multi-states, where AI, because personnel actions often involve PII, and the artificial intelligence is viewed as potentially compromising or disseminating PII too easily, therefore high risk, as the Europeans would say. The Trump administration says, not so fast. Are you kidding? We invented this stuff. We should be the leaders, and we're going to use it, dang it. And we're going to use it aggressively. We're in a race. They've analogized it as the race to the moon. This is like we're going back to the 1960s, where there was the race to the moon, and we're going to be first. And the administration lays that out with a lot of attention on labor market data. I would note they do reference the BLS. This was issued a week or two before the dust up with the BLS, so maybe that part of the order isn't viewed with quite such strong favor now. But in any event, that the notion is that there needs to be rapid implementation of AI in workforce related matters, which is a huge role for the Labor Department. Adriana, can you, I know you've really delved into that. Maybe you can share some of those details.
Sure. So as David mentioned, with this AI action plan, the Department of Labor is taking a very well, like the stance, if you will, on building the AI infrastructure. In doing so, they're going to be rolling out plans for training programs and apprenticeships, and this pivot is less about the coding and algorithms. It's more about building that infrastructure, building that base and foundation of job skills, because they understand and recognize that AI is here and it will change the workforce. And so this is interesting because it's kind of bringing, I mean, the government for the first time is actually trying to be a lead in preparing the industry, if you will, for and the workforce for this change that's going to occur. And this acknowledgement. So by doing so, they're going to be focused on creating these roles and for the skill base so that they, and again, with an AI focus. They're creating these industry-driven training programs and expanding their early career exposure programs. So it's not only just, it'll be like middle school, high school, pre-apprenticeship opportunities. So this expansion is very different from the previous administration and other administrations where before the apprenticeship programs, I would affiliate that with the department or with the Davis-Bacon Act. So I'd affiliate it with more with construction. And in this, the Department of Labor is expanding it exponentially from one focus to a lot of other industries, which is what the next slide here talks about, in that we have these EOs that were published by Trump and who signed, and it was talking about the high-paying skilled trade jobs for the future. And this was an unprecedented request or unprecedented direction to the Secretaries of Labor, Education, and Commerce to go ahead and create 1 million new active apprentices per year, and starting within the first or 6 months of the order. So this again is unprecedented. And then also a development is the fact that the Secretary of Education, that those apprenticeship programs and so forth are going to be shifted and moved to the Secretary of Labor, and so under the DOL. So we're seeing this reframing and that shift in the workforce for this priority of being AI, but also building out to the nuclear industrial base in addition to AI. So again, we're seeing this expansion.
Adriana, another point of another very recent development showing the expansion of these apprenticeship and training programs, we're seeing in at least one of these settlements that the administration has reached with higher ed, and there's a lot of open matters pending, a very high profile, but Brown is concluded and has publicly reported the monies there are going to be collected from the university over a period of years and used to underwrite the development of these types of apprenticeship and training programs that we understand are actually going to be run by the Labor Department. So, and I think that this is a trend that we're going to see more of. in the next 90 to 180 days as these university settlements more likely than not come in. And it is of course, the irony isn't lost on anyone that we actually have higher ed underwriting the development of alternative educational opportunities in the form of apprenticeship programs and not higher ed. But in any event, yeah, it does represent a very big growth area for this administration. And the Labor Department, as you mentioned, has gotten much bigger, many more responsibilities and a lot more money it'll be handling.
Well, David, I think we need to talk about where are all the Biden regulations standing, just to get everybody on the
Yeah,
same song sheet.
sure. So yeah, the unwinding of the Biden wage and hour rules, let's start with that. I mean, gosh, I feel like we could just sort of put tombstones on them, say RIP on the tombstone, but largely most of the Biden rules in a variety of ways are being undone. And sometimes that's simply by the agency saying we're no longer going to enforce the rule. Uh, they've used rescission of rulemaking. We talked about that approach earlier. The Justice Department, which is often litigates on behalf of DOL, has indicated it won't defend the Biden rules any further. The rulemaking that were underway, of course, they're stopping those short. That's easy and fairly common. And there were a couple of examples early on in the Trump administration where the Congressional Rulemaking Act, where basically Congress overrides a regulation, not only voids the regulation, but deprives the agency of the ability to engage in a future regulation on the same topic or area, unless Congress would authorize it. So those are very powerful tools. We've seen the Labor Department use one or more of each of these tools already in the first 6 months, and I think more to come.
Well, Adriana, what about our friends, the independent contractor rule?
Right. So the independent contractor rule will no longer be enforced. There was a bulletin that was released by the Department of Labor, or guidance that was released by the Department of Labor. And so in what David had just suggested, where they halt enforcement, this is exactly what's happening. There are still 5 lawsuits though challenging the rule. And this is because there are rules that were released with this, and they've been paused. Obviously, we're waiting to be rescinded, but at this time, the 5 lawsuits are still active. So it's an interesting situation at this time. But the ongoing litigation, it signals, or obviously they expect that the Trump administration will formally rescind it and then perhaps replace the rule with the previous Trump 1.0 rule, which was more of an economics realities test geared towards employers and narrowing that scope.
Well, let's look at the next one, which is the overtime rule. And this one gets a little tricky. So the Fifth Circuit has, DOL and the Fifth Circuit have agreed that they're going to stay the Fifth Circuit's appeal of the lower court decision blocking the rule. We've got the 11th Circuit also, as well as a district court, agreeing to pause. But here's the tricky part. The tricky part about these lawsuits against the overtime rule, is there is a challenge, and I think that's the Fifth Circuit case, that DOL did not have the authority to raise salaries of the employees that they need to have to become overtime exempt. And the other problem is, as they look to replace the Biden rule used the same methodology for determining what the amount should be that was used in the original Trump rule. So they're going to be walking a pretty fine line as they recalibrate, as it were. Adriana, your favorite, the federal minimum wage.
Yeah, the federal contractor minimum wage. So the Biden or the Biden EO 14026, which currently was set at 1775 as of January 1st, was revoked by President Trump. And interestingly enough, he still has to rescind the rules to the rulemaking process. But what's interesting is that an Obama EO 13658 is now effective with this revocation. And that creates a federal contractor minimum wage, or sets it at 1330. So it's an interesting development in that way.
I think AI must have missed that Obama rule, because I'm sure had they been fully aware of it, that they probably would have cleaned that out too. I do think at the end of the day, there are all these little different paths, hooks and nooks and crannies in the road, and efforts that are underway. But at the end, give it 6 months, we're going to pretty much be back to Trump 1.0 in terms of FLSA regulatory standards. I mean, a lot of people worry independent contractor, joint employer. I don't think they're going to revamp duties a whole lot. Maybe AI plays on that a bit. But I think that some of the others that we care a lot about, ICs and joint employer, it's Trump 1.0. Note, the administration has not yet published its regulatory agenda. I guess the spring agenda, we're just going to skip that one. The fall agenda is coming up. We do have indications that they are actively working on the agenda. So details, and we can determine whether our prognostications are right on some of this, but we do expect that agenda. I expect it will issue this fall. That may be something they wait for final approval till their new agency heads get confirmed, probably within the next 30 days or so, and we go from there.
Well, one thing really quickly is we were talking about overtime. AI could change overtime for white collar workers in a way that we really haven't thought about.
Yeah, Nita, this is a really interesting issue that I think people need to be aware of. I mean, there's so many ramifications as we think about how AI is introduced, but to the extent that a lot of the discretionary judgments are largely being performed or conducted by AI, with the AI user human just saying yes or no, then arguments can be made. And you talk to, and I do talk to some of the plaintiffs' lawyers that bring these claims. They're licking their chops. They are looking at a number of jobs that are being powered up with AI, where work duties are being augmented with AI a great deal. And they're looking to see whether the requisite potential reclassification will occur as a result. Um, I think that's a trend that is still in its infancy, but that we're going to see a lot more of.
Exactly.
Yeah.
Well, David, we're getting towards the end here. We have a few other topics I think you wanted to kick us off on.
Sure. So we've talked a lot about what's changing. Not everything's changing. Some things are, we think, largely kind of intact the way they were before. Child labor enforcement. I will say every time we talk to the folks at Wage Hour, they remind us to remind the employer community that child labor enforcement is still going to continue very strongly. Certainly, the Secretary of Labor has so testified in various congressional hearings, and a variety of statements have been made to that. There recently was mid six-figure child labor settlement involving Marjack Poultry in the last couple of weeks. So don't take your eye off that and supply chain integrity. Wage hour settlements continue apace. Literally every week there are published reports of, garden variety wage hour failure to comply with overtime, misclassification of employees, you name it. Wage hour is still in business doing that. So be attentive to that. We've talked a lot about how OSHA is revamping regulations, but that does not mean that OSHA is backing off of enforcement. And again, although there may be some regulatory changes, maybe in the penalties, maybe voluntary programs that you can take advantage of, again, garden variety, OSHA, and I should say MSHA enforcement, 100%. Davis-Bacon, prevailing wage for construction for laborers and mechanics, yes, still there. PLAs, Adriana mentioned that before. She's talked about that. Any project that's 35 million or more, I'll be honest, this was a big disappointment that this program was not discontinued or cut back a little bit. It was not. This is exactly how it operated in the Biden administration. Most of our clients didn't like it then, and most don't like it now. But there it is. That continues. But Nita, how about your favorite agency, OFCCP? What is it or isn't it going to be
Well,
the
that's a really good question. I mean, I think is it or isn't it a zombie agency? Um, it's interesting. I am working on a letter of comment for the Institute, and when you read the proposed regulations, they don't talk about OFCCP except in one or two places. everywhere else in the proposal, they talk about the DOL, the DOL. So, I mean, I think if they have their choice, the OFCCP is dead. We will be talking, David, and I think we don't want to get too much into this, but federal contractors need to remember that if they have that voluntary submission that the director of OFCCP is requesting by, I think, the 27th
Right,
of
of September.
September, that they need to think pretty hard about what they might submit to to OFCCP at this point.
Yeah, and I just will put a pin in that, Nita, and we've talked to a number of clients about this already. That's a little more nuanced decision, even though it's not mandated, even though many people had the initial and understandable reaction of, well, if it's not mandated, I'm not going to do it. There are potential consequences for those that don't do it, the lists that they may get put on, the evaluation, the scrub they may be given by various folks, including at the Justice Department and other agencies. So, yeah, I love the slide, and I think I predict that OFCCP is not going away. I think it is the zombie agency, but we'll see.
Well, David, I think we also are still dealing with Jarchese, and so what's the
Yeah,
latest on that?
latest Third Circuit. That's that Sun Valley Orchards versus DOL case. Third Circuit decided very recently, basically saying, hey, wait a minute, the whole administrative law judge ALJ process that imposed fines, that is unconstitutional under Jarchese. It implicates and deprives employers of their Seventh Amendment jury right. So the ruling is that those sorts of proceedings have to go through an Article 3 federal court. I just would say, as a practice pointer here, if you're faced with these proceedings for a DOL ALJ, you need to look carefully and potentially, at a minimum, raise as an affirmative defense what I call a Jarchese defense, whether the ALJ and proceeding is in fact licit or not.
I think that this means that there's two circuits where this is true
You're
because
right,
you
Nita.
also have
Yeah.
the Fifth Circuit as
We had
well,
the
David.
fifth now, so 5 and 3. Yep.
Adriana, we've got the last slide for you. What? What about college sports? That has anything to do with DOI?
It's football
Right.
season. What do you mean? What about college sports? It's great.
Right. So, in section 3, it instructs the NLRB and then DOL to clarify that the status of student athletes, but then obviously provides no substantive guidance or timeline or policy framework, because that's what NLRB and DOL are going to be doing, is providing that guidance and providing the tests that are used to establish whether a student athlete is in fact an employee. Now, interestingly enough, there obviously, well, you might have heard there's some several cases that have been tried as far as whether students are athletes are considered employees, and the EO appears to push back against those recent efforts to classify students athletes as employees under NLRA and FLSA. So despite those efforts and traction that might have been gained, this appears to kind of shift the direction and saying, look, NLRB and DOL provide this guidance, but we don't know whether that is going to. I mean, I anticipate this is not going to stop the cases from going, just guidance going forward on what pertains or what creates a student athlete for the employee, whether they are an employee or can be classified as an employee. And this goes to a big piece of employment side, meaning whether student athletes will be able to unionize. So this is something that's very interesting and to watch as it develops.
Additionally, if they're an employee, presumably they'd be entitled to overtime. I'm not aware of a white collar exemption that fits them perfectly. Maybe professional entertainers or something, but I don't know. It feels a bit of a reach. But in any event, this is interesting to me because the Biden administration didn't hide its light under a bushel on this one. Said, of course, they're employees. Put them on. They got a bargain with them. They get overtime, everything. But the Trump executive order is a little more nuanced, which is look at it and address this, but it's just in sharp contrast to everything else. It's so prescribed outcome on, a whole variety of issues. Here, it's just saying, look at it. And so I don't know. I mean, I
Yeah.
think they will probably be found to be student athletes, non-employees, but the order doesn't direct that specific outcome, which I
Correct.
which
just
is
find
very
interesting.
unusual for this
That is,
administration.
yep.
Extremely unusual. And if you want to think about being punitive to higher ed by making them employees and putting them on the payroll, that takes a lot more money out of higher ed. So maybe that's a motivation too. I have no idea.
Right.
So, David, I think we are at the end of our time today.
Darn. Yeah.
What do we want to, how do we go about this? Who do you want to kick off on our final thoughts?
Yeah. Well, let's go. Let's just go quick round robin. Adriana, why don't we start with you and Nita, and then I'll wrap it off.
Okay.
Sure. My main focus is on these collaborative programs that have been rolled out by the Department of Labor. We're already getting a lot of calls about that, discussions, and in progress with some of those programs as well. And so it's interesting how much of a difference it is compared to the previous administration in working through and trying to find a good answer or a good opinion letter or a good resolution for our clients. So I'll say that's a
Nita.
positive.
So OFCCP, I believe, as we said earlier, is not going to be dead. I think they may turn to it because it has audit authority to enforce our favorite executive order 14173, which is basically anti-DE&I. That's kind of my thought, and they're going to get the money for it.
One final thought I have is that a little noticed agency at the Labor Department called the Office of Civil Rights, that normally is thought of as handling internal complaints, also has jurisdiction over all the grants and training monies that go out. Now, think about all these programs that we've spent time talking about. We're talking billions that are going to be pushed out. Every dollar that goes out has a non-discrimination, has an EEO clause in it, and potentially provides the basis to extend and expand the illegal DEI prohibition that the president has put in place. I would stay tuned for that because the Labor Department hasn't been as active on the enforcement front on this. It's really been DOJ, principally DOJ and EEOC and the White House. The Labor Department may be getting into that game through the OCR, even if OFCCP is the zombie agency and beats the clock and survives. But there may be some new approaches that we haven't seen before, tied more to the grant side, similar to how the administration has very effectively put the challenge to various universities based on grants received under Title VI. That would be the model that might be followed.
Well, we would like to thank you all for joining us. If you have any questions, please email us at info@fortneyscott.com. A recording of this webinar and a copy of the PowerPoint will be available to all who attend. This will be sent as the webinar recording is available. Please stay tuned for our next podcast, which will be on similar subjects around Department of Labor and webinar.
Thanks, guys.